Go ahead and start the recording. Good afternoon, everybody, or good morning, I should say. This is the Incarceration Prevention and Reduction Task Force Legal and Justice Systems Committee. It is July 9th, 2024, and it's 11:31 in the morning. We don't have a huge agenda today, so we may get through this faster than the hour, but I'm sure nobody will complain about getting a few minutes back. I could be wrong on that. I'm going to go ahead and start with the land acknowledgement statement. Before we begin, we acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect and connection across all barriers of heritage and difference. We begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to the elders, past and present. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that bring us together here today. And please join us in uncovering such truths at any and all public events. All right, so calling everything to order, and we are going to kick it off this morning with a Superior Court pretrial services update by Alan Epps and assisted by Stephanie Kraft. Before I begin, I don't see everybody, but I wanted to welcome Tammy Bennett. Also, Tammy is the new Darlene, I guess, for Bellingham Municipal Court. She is now the administrator, and we're glad that she could join us today. So welcome, Tammy. And I'm going to turn it over to Alan.
All right. Thank you, Raylene. I have a PowerPoint that I can share. Hang on a second. Sorry.
Jill, can you make sure that Alan can share?
Yes, he has shareability.
Is it there?
Yes, we can see it.
Okay. So, pretrial services. Whatcom County Superior Court pretrial services. That is. It won't scroll. Hang on. There it is. Our mission statement is, I'll read it, even though you can all see it on the screen. Pretrial services provides judicial officers with impartial screening through the use of the public safety assessment to promote fairness and equity and release decisions made by the court. Our goal is to provide defendants appropriate supervision and community resources necessary to minimize pretrial detention, maximize court appearances, and reduce failures to appear. So, pretrial services, for those of you, I'm just going to do a general overview for those of you who don't know what pretrial services is or what we do. Pretrial services, we began shortly after, or excuse me, late 2019, supervising clients, and shortly after we began, COVID happened, and it slowed our department pretty much. We pretty much had to start over after COVID-19, and then after the growth kind of slowed and stopped, John Kraus, the previous manager, left the department in January of 2023, which left us without a manager for most of 2023 while the hiring process happened. I was hired late 2023, and then my position was backfilled early of this year, January of this year, by Kelsey McDonald. She came to us from juvenile detention. I think Stephanie can correct me, 18 years in juvenile detention. So she has a lot of experience in our system here, or our county, excuse me. We're located on the 5th floor, just in front of Superior Court Administration or Juvenile Detention Office, Suite 535. Our contact information is as follows. So a basic overview of our department. I'll kind of summarize it, and then I'll come back and explain a little bit more of this because you'll probably have questions about the PSA and about CE pretrial and things like that. So like I said, we began in 2019. We were using Excel spreadsheet at first to monitor our clients, which was very tedious. It was kind of hard to manage. It was difficult. John Kraus, the former manager, was able to do some research and find that a lot of companies, or excuse me, a lot of pretrial agencies around Washington were using CE pretrial. It's a web-based program. to record client information, do data management, pull statistics, things like that. And it's been a really good program for us. I know they've spoken in the past about upgrading us to, I think CE was going to move to Ames or Ottoman, which they tout to be more robust with data management and things like that. We haven't seen that yet. Most of us Washington pretrial groups were promised that a few years ago, and that still has yet to come to fruition. So I don't know where we are in that process. After a lot of research from the pretrial process work group, and at the time it was Commissioner Heydrich who was sitting on the bench, they determined that the PSA is a risk assessment tool that had reliability and was validated. And there was other pretrial agencies in Washington that were using it and getting good results for, for impartial screening of defendants to aid in the judicial officers' decision-making. Excuse me one second. We monitor clients who are ordered to our office by doing office check-ins, email, phone, text messages, and we provide text messages for court reminders, both text messages, email, and also phone calls for court reminders. And we do monthly, at least monthly, criminal history checks on everybody who is ordered to our office. We assist them. We meet with them and we build rapport and we try to see what their needs are in the community, if they have any. And it's not to say everybody who comes to pretrial services is in need of something. But if they are, we have community resources that we can refer them to, such as what I've listed there: food banks, cell phone assistance, housing, treatments, mental health treatments, things of that nature. The PSA. So the PSA is a nationally validated pretrial risk assessment tool that assesses the pretrial likelihood of failing to appear, having new criminal arrest, or having new violent criminal arrest. This is done through using static information that we are able to get off of NCIC and JABS. That's in the next slide. I'll explain that a little bit in the next slide. It was never made to replace the judicial officer's decision-making process. It was helped, or it's designed to aid in their decision-making about those three things, about those three prongs: the new criminal arrest, violent criminal, and failure to appear. So as I said, what is the PSA? The PSA is based off of 9 questions. It's housed within the CE software. So there's just another link after we add defendants to our software system. Not only is it good for tracking office check-ins, court dates, things of that nature, it also has this program that CE has embedded, I guess you could say, for easy access. And we use JABS, which is the Washington State criminal history, criminal and infraction history for defendants. And then we use NCIC when applicable. I say when applicable because they're rated in 3 levels right now: low, medium, and high, as far as how our grid is set up. And if they fall into the high level, which would be considered a high likelihood to reoffend and a high likelihood to fail to appear, excuse me. If they fall in that, we don't have to request NCIC. It's not necessary because there's nothing that NCIC could tell us that would increase their score or their likelihood for those items. But if in-state JABS history does not show enough criminal history, I guess you could say, or enough just to make them score high, then we request NCIC from somebody in Superior Court Administration in the office behind us, and they were able to run national criminal history on the defendant. And we just answer those questions. There's no guessing. It's all just information that we have in front of us, and we present it by answering these questions. To break it down a little further, violent, it says here, prior violent convictions. I don't determine what a violent conviction is. We have a list that we go off of. It's the same list that Yakima uses. I believe Thurston County uses the same list, and it spells out, or it shows you what is considered a quote violent conviction, and a failure to appear. In order for it to be a failure to appear and for us to count it, there's been a lot of discussion recently about willful flight and having notice of a hearing. So in order for us to count it, there has to be something noted in JABS or NCIC that shows that the defendant was given notice and that they failed to appear after that. So it takes out a little bit of the guesswork. Again, we're not trying to fabricate this information. We're just reporting on what we see and what we read in the notes. And then a prior sentence to incarceration is 14 days or more. That could be EHM, could be in custody, obviously prison, or house arrest. Those all count as sentences. This, it looks busy. It's really not that bad. Let me see if I can pull my notes on this to see how I can explain it easier. Okay. So some of these are statutory requirements set by the court, but like it says there in the checkbox. Actually, let me back up a little bit. I told you when we run the PSA that we score people in low, medium, or high, but on this it says low / medium and high. Right now, we are only operating at 2 levels. Low and medium are the same requirement at this point, and then high is its own requirement. And so the check boxes relate to what is enforceable at said level. So if you go down 3 on this, let's report to pretrial services within 24 hours of release or referral. If you're on high level and you're released, you have to report in our office or in-office intake. But the lows and mediums just have to make contact with us. So phone is the easiest way for them to do that. But oftentimes they come in office anyways. And then this also shows the actions we take. So, and some of these are not exclusive to just pre-trial technical violations. So if you notice, it says a notice of alleged violation, an NAV, is filed with the court if referred individual does not report to PTS office within 24 hours and cannot be contacted. So that's a technical violation. But then there was then there's if they commit a new law violation. Well, we report that to the court, but that's not necessarily a violation of pretrial services conditions. That's a violation of court order. We file the notice of alleged violation after doing monthly criminal history checks or routine criminal history checks, excuse me, to notify the court that said individual has committed a new crime or allegedly committed a new crime. So we attend all in custody first appearances. We stopped for a while there. So after COVID, we were doing it before COVID. We kept doing it a little ways into the pandemic, but then things started going on restriction, started limiting in-person contacts, and all that had us pull back from the jail. And we didn't go back into the jail for first appearances. I want to say it was early this year when our office was finally fully staffed after hiring Kelsey and then myself as the manager. We get the referral or the order from the court that the defendant is to be on pretrial services and at what level. And then after that, we introduce ourselves and we go into a side room and we make sure to gather some information from them. So we can collect it, and it all depends obviously on the state of the client. Some are kind of distraught or confused about the process. So we kind of help explain that a little bit too, without giving legal advice. That's not what we do, or what we're allowed to do. But we try to get some good contact information so that in the chaos of all this experience with them, they'll be able to remember, hopefully, how to contact our office or how to get in contact with our office. So we record some contact information from them, basic name, date of birth, cell phone, email, address, and then while we're listening to the court hearing, a lot of times we can glean a lot of good information. The public defender, or excuse me, the defense attorney will mention services that they're already engaged in or services that they've already sought out. So we'll make notes of that on our intake form. And so when we sit down with them in the side room, we can say, you know, it was mentioned that you might be interested in LEAD or that you're a part of the GRACE program. And so that's another way to kind of build instant rapport with them as well and let them know that we're not just an office that you have to report to, that we're there's a face to the office, one, and two, that we're there to help them get to these services. And then obviously we can also get that information is used to help refer them to the necessary places if they're willing. It's all voluntary at this point. We register in VineLink. If any of you don't know what VineLink is, it's an awesome service that tells when a defendant has been released from custody, and it also tells if they're already pre-registered in VineLink. It'll tell them if they're ever brought back into custody. So that's very useful information, especially when we're trying to monitor or supervise, if you were, these defendants on pretrial services. This is kind of piggybacking on the last one. So based on how the conversation goes in the jail and then the intake process, when they do come in the office, we can glean more information about what their needs are. Kelsey has done a fantastic job at reaching out to community resource groups, and she's compiled just a bunch of things that we can refer to them. There's cell phone assistance, housing, shelters, how to get free showers or free hygiene products, food vouchers, assistance. And she's done a great job at kind of, you know, I have a whole bunch of it here that I was actually reviewing this morning too. And then we also give out ride passes for WTA transit. And then to finish up, I may have gone through this kind of fast, and I apologize. I'm sure I will be asked questions and I can fill in some gaps. But this is where we sit as of June. 105 PSAs were completed, so that's 105 PSAs essentially were at first appearance in the jail. 19 were directed to report to our office. We have 108 individuals on our caseload. 48 are at that high level, 29 medium, and 31 low, with the caveat that there is 38 remaining in custody. And then we completed 154 check-ins and handed out 72 ride passes for the bus. I believe that's the end. Yes. Thank you. I know I may have rambled a bit. This is my first time presenting with PowerPoint, and you know, my mouth dried out a little bit and I was struggling my way through it. I appreciate your patience.
Thank you, Alan. You're doing a great job. We really appreciate the presentation. Does anybody have questions for Alan? I'm not seeing any hands. That must mean you did fabulous.
Sorry,
I've,
Rainey, I've got Peter and then Stephen have their hands raised.
Oh, great. Thanks. I'm sorry. I just switched my computer and I'm trying to see everything. So if, yeah, go ahead, Peter, and then we can go to Stephen.
Thanks, Raylene, and thank you, Alan, very much for the presentation. You did a good job. I know more than I did before I sat down here, and that's a good thing. Can you fill us in on how, you know, what success looks like? What are the metrics you're looking for month by month, quarter by quarter, year by year, to know that your office is having the appropriate effect that we're going for? can you talk through that a little bit, or maybe
Well,
Stephanie?
yeah, Stephanie and I actually talked about this morning. Stephanie, did you want to step in, or?
I think that the data collection has been one thing that we're trying to figure out exactly what points to collect data on. And we've done a lot of adjusting over since the beginning of the year. And so it's hard to answer that question. The other piece is we don't have any information to compare it to. So if we're collecting information about the people on pretrial and whether or not they're attending court, where is the similar data coming from those that weren't assigned a pretrial to be able to say what's effective here? And so there's some holes in the information, like what do we collect and what do we compare it to? And if we don't have anything to compare it to, what does it mean? What does the information we can collect mean? So I think that that's a really good question.
And maybe Judge Jones can speak to this if that would be appropriate. I am curious, what portion, what kicks off an assignment to this office? What, are there any balls that we're not, that we're dropping? How can we do better? How can we get the information that we need to know that we are, that this program is helping us in the incarceration prevention reduction work that we're trying to do in this county? Just anybody, I'd be curious.
I can jump in a little bit too, Peter. So I think what Stephanie's right. We've had some observed difficulties in the data collection, and so that we can make kind of comparisons to our work versus not. But what's also true is this department, at least even in the last year, we've been pushing hard to be more of a case management or case manager model as opposed to some sort of enforcement model. So our successes, I think, end up looking a little more anecdotal. They look more like, oh, we got somebody referred to a service that they needed. We helped somebody with with confusion regarding the process. We were there when somebody had a question about when their next court date was. So those are not, we're having trouble tracking those interactions, but we know they exist. And I think Alan will tell you those are the moments when he feels successful in the work that he's doing. But it's anecdotal like that. It's just those moments for those people, but we don't really see that, on a grid with a trend. So I'll say that, and that's quite a bit different because we're working hard to have that model and moving away from what people expect. It feels like what people expect, which is to be more of a probation type enforcement model, which we are not wanting to be. So I don't know if that helps. That's my perspective.
Thank you.
Yeah.
Stephen?
Thanks, Raylene. Thank you, Alan. Appreciated the presentation. I'm going to layer a couple of quick things on here. Just speaking to Stephanie's point and a little bit to Judge Jones. The PSA is used in other jurisdictions. The worst thing we could do is to start from scratch when we don't need to. So if you're looking for what data to collect or what data points to measure and intervene at, wouldn't it help to contact those jurisdictions and find out how they're using follow-up on the releases? I don't know if anybody's done that, but it seems like that would be a useful step, at least to get us some information. Certainly we need to localize what our goals are, which may be slightly different than other jurisdictions, but I'd encourage you to ask around because we know there's experience out there we could learn from. In terms of questions, two quick ones for you, Alan. One is, I noticed on your last slide, and thank you for that kind of data, you had 100 assessments, 105 assessments in June, 19 were referred to you. That strikes me as an unusually low referral percentage. So I'm wondering what the explanation is for that and what became of the other, whatever it is, 86. Secondly, when you do have a notice of violation, well, I guess I'm going to ask, how many notices of violation do you have? Do they result in a hearing before the court? How timely is that hearing?
Yeah. I'll take them in order. So your first question, 105 PSAs were completed and only 19 defendants. So it is still up to the judicial officer to refer them to us. So they still have that discretion. It's just because we run a PSA and it says they're a medium risk, or it says they're a high risk or a low risk, they're not obligated to send them to our office. So I guess the best way to answer that is that because the judicial officers have so much discretion, they're putting the ones on pretrial that I think maybe could benefit the most from it. And it may not be 105 people benefit the most from it. Maybe it's just the 19. I can't tell you that definitively, but that at face value, that's what is happening. They're only referring based on what they feel. And we have typically 2 to 3 judicial officers that hear first appearances, but there are pro temps that sit in that may not fully understand or know about our office. That might limit the referrals. So that could also have played into effect or have played into it in June. As to the second question, can you refresh my memory, Stephen? I'm sorry. It was.
Yeah, I was interested in how many notices of violation you sent back to the court, how often and how timely there's a hearing on those.
Yeah. The notice of alleged violation, there's for new criminal activity is the one that we file the most, I would say. So anybody who is accused of allegedly committing a new offense on our caseload, we'll notice that we run criminal history checks using jabs at least once a month. On some of the high levels, though, we have them on either an every other week or an every 3-week cycle, just so we can monitor them a little bit closer and make sure that they're abiding by the orders of the court. I don't have the number though. I could get the number maybe, but it's when we fill the violation report, we're starting to track. There's a tab in CE that's let me just lay eyes on it right now, so I'm not telling you wrong information. I believe it's called violations tab, and we can add a new arrest. So if they're in CE and they have a case open and we notice a new criminal activity in jabs, we can hit the new arrest tab, add what the arrest is, and then we file the violation report separately. It's a Word document that we generate. Of those, right now there's a little bit of we'll call it resistance for the prosecutor's office noting those up, but we do file them with the court. We file them with the prosecutor's office and we give them to the defense attorney. So once we file it, it's up to, and unless the commissioner explicitly orders a hearing right off the notice of alleged violation, it's up to the prosecutor's office to note it up for review. So of the ones we're filing, I would say very few get noted up for review, even after we've forwarded to the appropriate parties.
Has the prosecutor's office articulated to you any reason for their resistance? Or, not to put you on the spot, Judge Jones, but as a former prosecutor, would you speculate on what the problem is there, not noting those new crimes?
I think some of it is just education. I think they were used to a system where, most of those prosecutors are used to a probation type model where there's kind of immediate consequences for violations, what are seen as violations of pretrial release. Alan said something that's important there, that we're not, this program is not meant to monitor conditions of release and react in a way to enforce those conditions. It's meant as a service program. So I think the prosecutors, there's a little bit of this is from my perspective from the outside, but there's just a little bit of a resistance to kind of transitioning to that model or seeing it as beneficial to their prosecutions, as opposed to maybe, helpful to the defendant, which for whatever reason they don't. It just isn't in what their motivations in court sometimes. So I think that's it. They don't see, we've let's see, the court's taken some steps recently to change our violation process, where we're simply providing notice to the parties when a criminal, say a criminal history check reveals a new crime has been charged. We just provide notice rather than do anything ourselves as a court. Provide notice for the prosecutors or the defense attorney, frankly, to note a defendant back up in front of the court. And I think the prosecutors don't like that. They see that they keep saying in court that we're somehow pushing liability onto the prosecutor's office for them responding to violations rather than the court itself responding. So there's some resistance there. There's also just a practical consideration that the prosecutor's office sends one prosecutor to every court hearing, every first appearance court hearing where issues, pretrial services is often discussed, and that there's just some resistance from that individual prosecutor. So we don't see a lot of variety from the prosecutor's office on those positions. Those are kind of the reasons I see. Oh, I did want to say too on this point, Stephen, we're sorry, I'm talking a bunch, but we are attempting to educate everyone the best we can. Alan and I met with all of the commissioners and invited all the pro tems, the regular pro tems, to introduce them to pretrial services, give them a presentation about what the program is. We developed and provided a new bench card, which is a kind of a cheat sheet that the judicial officer can have on the bench about everything pretrial services does, so that they have that information all available to them. We meant to encourage more referrals from the bench by doing all those things. And we're also, I hope Alan knows this, but we're also soon to be scheduled to meet with the prosecutors at their weekly meeting to do a similar presentation directly to them and answer questions or concerns they might have. So we're doing all those things.
Thank you both for those answers and that update.
I have one other thing about can I? Sorry.
Yes, please, Judge Johnson.
And maybe Stephanie can help with this too, because I think an exciting thing is that we've identified some funding through administrative office of the courts that we're hopeful about. They have an opportunity for local jurisdictions like ours to become part of these pilot, what they're calling a pilot program. We're not quite sure what strings that all means, but it does mean dollar bills, I think. And though we're hoping if that sees fruit, that to use some of these funds to kind of further develop the program, to continue to validate our PSA so that we have some confidence and data that we can glean from that, especially and compare it to other jurisdictions even. But there's some funding that needs to happen to pursue all those things. We also we're talking more and more about expanding the program to include things like EHM on pretrial detention. These are preliminary conversations, but we are moving along with those sorts of conversations.
That's very helpful, Judge Jones. In fact, that kind of leads us to moving towards the district and municipal court pretrial services, as they have been doing pretrial services a little bit longer than the Superior Court. Jake Webush has been instrumental in assisting the courts of limited jurisdiction. I think probation for Whatcom County covers all the municipalities and district court with the exception of Ferndale Municipal Court. And so they've got a pretrial services program that he spoke about in the past, but Judge Anderson is with us. She worked at the Public Defender's Office and was part of the task force before. And Tammy Bennett, who is the municipal court administrator for the city of Bellingham, is on board, and they have utilized these services as well. So it's kind of hoping to get a little bit of feedback to educate the differences between the district and municipal court pretrial services to the Superior Court pretrial services, and just kind of educate where we're at and what we're moving towards. So I'm going to let Jake take it away first.
Well, thank you. I saw that Judge Anderson and I think Judge Rands is in a trial, and Tammy Bennett were on the agenda, and I don't want to, I think I'll kind of allow them to fill in what they wish to present here today, and then perhaps I can go in, fill in any gaps or any questions that others might have. So I don't want to step on their toes. Go ahead.
Thank you. Judge Anderson, I see you popped up.
Sorry, I had a call from Judge Freeman about a trial, so I apologize. I couldn't figure out how to send you guys a message. So bear with me, I'm playing a little catch up. What was the question?
So we just discussed the Superior Court pretrial services. Alan Epps did a fabulous job of presenting how that program is going. Judge Jones filled in some of the gaps on what we're moving forward, along with Ms. Kraft. And now we're looking at the pretrial services programs through the district and municipal courts. What is being done, what could be done better, what gaps are there, what the differences are between Superior Court pretrial services compared to district and municipal.
I mean, I'm probably not in the best position to talk about that. It really probably should be you, Jake, because I just see it when a violation shows up in front of me. And I particularly don't know municipal, and I don't know a ton of the differences between the two. I can tell you from my standpoint, it does feel like it's working very well. We have a very robust pretrial program. We have a calendar on Fridays to address both of those. And they're really on top of it. We're getting UAs done. And if there's a violation, I'm seeing it within 2 weeks. Judge Rands and I have a real philosophy that incarceration is the last resort. Do our best to be creative on problem solving, getting them into compliance with sobriety and making appointments. But maybe I will just turn it over to Jake. Do you want to kind of describe district courts in comparison?
Sure. Yeah. So we are referred the referral straight out of court. The judge or commissioner puts them on pretrial monitoring, and they come to us. We don't do a pre-assessment. It's given ahead of time to the court. The probation staff receives it, and the conditions are set at that point. And we then make sure those conditions are followed, and they show up for court dates, and that they very often remain sober and clean when we're doing testing. We have a specific pretrial unit, and we also have cases that are referred to behavioral health unit if those needs are needing to be met, as well as a high-risk domestic violence unit if those are factors in the underlying crime. So they could be on the pretrial unit or on to other specialized units depending on the needs. Again, we monitor the conditions that are set. We do have programs through district court, which include alcohol, a bracelet that detects alcohol as they wear, or a device that they would then blow into between 4 and 6 times a day to detect alcohol. I believe we probably have around 35 individuals that are on pretrial through district court that also have one of those devices attached to them or are required to do to remain sober. So it's not always do they come with those when they're referred from pretrial from the court. Sometimes, like Judge Anderson said, they'll be in violation, go back before the court, and potentially one of those devices could then be placed on them to make sure the sobriety is maintained. With the city of Bellingham, we also, and Tammy can please jump in, we do very similar services, except they have a contract. I should back up, excuse me. District Court works with the Jail Alternatives, Whatcom County Jail, in conjunction for the bracelets and the sober devices for the district court referrals. City of Bellingham does have a contract, and I want to again, Tammy, with FDS for very similar devices, as well as in domestic violence cases, GPS to restrict zones for defendants to refrain from. So that is another element that we have for those pretrial cases out of the city of Bellingham. That kind of describes a little bit about it. I might have missed some things, but Tammy, I don't want to go ahead.
No, Jake covered most of it pretty well for us. We also have, since we have the contract with Friendship Diversion, we're able to do home detention for people for pretrial versus having them sit in the county jail while they're waiting for their case to move forward. We're able to use that for lower level offenders to get them out of that. And that way also they can maintain employment or their schooling and their housing. So that's the only thing in addition to what Jake had.
You know, I will add, you know, obviously we have the conditions that they have to follow, and those are primary. But if there's other things that come up, other resources that are in need, we get ongoing training on every other week basis within the department to make sure we know what's going on in the community, and all of our probation staff have those at their fingertips. So we will obviously provide those, any assistance we can with the time we have to the individuals that we see. However, the primary concerns are following the conditions that are set. Hope that answers some questions.
Thank you. And I also want to, I know she's on mute and she's covering her camera, but Tracy Cruz is the administrator for the city of Blaine, and she's also on Zoom here. So we've got two administrators. And although Tammy is new to her position, she has actually been with Bellingham Municipal Court for quite some time. Has it been 10 years?
17 now.
17 now. So I was
Yeah.
gonna say, I know she's been there for a while. So
Yeah.
she's quite knowledgeable on how this all works. And when you mentioned the part of EHM, so just to touch on that a little bit because of my background, and I know when we had pretrial services in a municipality, they could use the pretrial monitoring that would restrict them from going into certain places. Usually that person was basically a high offender. Usually it had to do with several DUIs or ignition interlock cases. And Judge Rance might actually remember the statutory language because I remember him using this in a municipal court. But the individual that was put on pretrial services had two bracelets on. One was to detect alcohol. The other one was to keep him from going into bars and taverns. Those restrictions that were used on pretrial service were able to be converted to EHM and used for time served once that individual pled. And it was part of the statutory language under DUIs. And so it was able to be used in a different format. And I can't remember all the specifics, but like I said, I do remember it being implemented to assist the individual at sentencing, and several individuals that were on these monitoring I had success stories and said that it was the first time that they had been sober for so long. So that there was definitely some positive things that came out of it. I know it's not a perfect system. It's not going to help everybody, but anything we can do to try to assist and get people better, I think that's one of the goals here. But I see Peter's hand up, and I also see Judge Jones. So I'm going to go over to Peter and then Judge Jones.
I'm going to ask a similar question to what I asked Alan and the Superior Court. What does success look like? What are when you're looking at your reports or whatever reports that you have on a monthly, quarterly basis? What is it that kind of opens your eyes and is like, oh my goodness, things are going the wrong direction, or perhaps the right direction? What are those metrics that you're looking at?
I think there's probably three elements to that. Reoffense while on supervision, making sure they show up to the hearings, and then, are we providing them with a service that they can, improve their life as well. We don't have any straightforward right now statistics, but I think those three would probably be very close to what generally we're looking for there. I don't know, Judge Anderson, I believe Judge Rand's is in here now too, if he wants to jump in there.
I think you nailed it. And then yeah, community safety, the no recidivism, knowing that someone's in compliance with a TAD bracelet sure makes me feel a lot better to give a continuance on a case when I know they're being monitored. I want to clarify something Raylene said, that I just have to say it as the judicial officer. Our pretrial program does not qualify for district court, qualify under any statute for credit for time served, or can be applied towards their sentence for jail time or monitoring. So when if a case for some reason takes 18 months to resolve and they're on pretrial the whole time, it does not count towards their sentence.
Does that include if they're on a bracelet that whole time, Angela?
Yeah, if they're on a SoberLink device, we don't do a GPS bracelet out of district court. We don't have the ability to restrict geographic conditions.
Yes, not confinement. That's just for alcohol monitoring.
Yeah, in Bellingham, we do have a home detention bracelet pretrial that's in lieu of bail, and that they've been able to use towards sentencing because it is the same as being home, it's home detention. It's not one that restricts their movement, like you can't go into a certain address or within a certain zone. That's the GPS. But when they're on the pretrial home detention in lieu of bail, we've used that towards sentencing credit.
Could I add something real fast? Jumping on what Jake said, that how they, Peter actually brought up the question again, what does success look like? And I was thinking about it more. Success on pretrial also were the things that Jake mentioned, the no reoffense, complying with court orders, things like that. But it's also satisfactory case resolution. We want to get these cases resolved. That doesn't necessarily mean everybody has to take a guilty plea, but it could mean guilty plea. It could mean case dismissed. It could mean deferral, appropriate deferrals. It could be recovery court. So we can also measure success when we close cases of people that are on pretrial services within our software. We can log what the resolution was, whether it was satisfactory, which would be one of those resolutions, or unsatisfactory, FTA, or being removed for another reason. Right now, the only purpose we remove somebody is either with a guilty plea or a failure to appear. There's, I forget what they're called, administrative orders? No, something that allows us to remove somebody from pretrial services once they go on warrant status.
So I had a couple quick questions. Tammy, first to you, and I remember working with you in Bellingham Municipal way back when, so I can attest to those 17 years. But so my question, I had some questions about the contract with FDS, and I'm wondering if there may be specific questions about how payments made and those sorts of things. Are you someone I can reach out to for that, or would you refer me somewhere else?
I would be, go ahead and get a hold of me, and we can go from there.
All right, that's great. And then my other question about FDS or folks that are by court order put on some version of GPS or home detention or any of those things. How specific are the court orders out of Bellingham? Are the judges reducing to order things like when someone's allowed to go to the grocery store, when they're allowed to come back, when they're allowed to, pick up their kids from school and back, or is there some discretion that's left either to Jake or a probation officer or FDS to make those particular determinations?
Yeah, we have a pretty specific order. That's just the general blanket order that allows, with proof that people can go to work. They have to show proof of their schedule, doctor appointments, attorney appointments. We do have a caveat that if someone is spending more than 5 days on the home detention, they're allowed an hour a week to go to the grocery store, to go to the bank, go to the gas station. If they need anything above and beyond, and there's a few other like counseling, therapy, appointment or a part of that general order as well. If they need any specialty allowances, it's usually done by an agreed order that's submitted to the court. The judge reviews it, and then we send it off to FDS to allow for those special things. We've had people that ask permission to go on job interviews. And of course, we want them to be able to work. So that's allowed as long as we know the place, the time, so Friendship Diversion can track where they are and that they're supposed to be where they are. So I hope that helps.
It does. Thank you, Tammy. I'm going to reach out to you too.
Awesome.
St. Peter's frozen.
Nope.
Oh, there we go.
Do you hear me?
Yep.
Okay. I'm just so curious why it is that only Bellingham has home detention. It seems like, and maybe I don't know enough about it. I thought I did, but why don't district court and superior court have home detention? It just seems like a really good strategy, and maybe there are legal reasons that I'm not aware of. And
Yes.
you know, I'm fairly new to this committee. You know, I've only been on it for maybe a year or less, and so maybe this ground has been tread before, but it does seem like an excellent strategy for us in Whatcom County to pursue. Anyone want to take that one?
I can a little bit. Jake, you can chime in too. Bellingham got it because remember the sheriff and Bellingham did not get along and lost access to using the jail a few years ago. So
Right.
they had to get creative and come up with a new solution to incarcerate individuals. So they developed the contract with FDS. I don't have that problem. I have a sheriff's office that will incarcerate individuals, and I use their products, which are the ankle bracelets that they provide post conviction. So I have EHM after conviction. I don't have the ability with the sheriff's office right now to do pre-trial home detention. That could be something we explore with FDS, but we have a new sheriff that's looking at things, and I don't want to step on his toes what he might end up providing in the future. I'll say, without going too far judicially, there are some very big legal concerns that happen when you incarcerate, you do home detention and try to give credit for that. And I'm sure Judge Jones and Judge Rands are there. Bellingham's an exceptional circumstance. I'd rather have Judge Lev or Commissioner Henry explain how they're able to do that on some specific charges, but I'm not you're getting into a lot of legal weeds when you start to incarcerate people pre-trial at home and what that looks like and whether it's detention or not. But I will say, just as a total not judge, but as a former Linden public defender, I did really like having the GPS monitoring pre-trial. It is a nice option and it does ensure a lot of community safety. And I hope that the sheriff's office maybe looks at developing some of these additional tools for us to use. That's a real roundabout answer. I hope that's helpful. Politics.
I guess I can answer for Superior Court. You know, we've always, it's always just been an impression of Superior Court that we have a population of offenders that are a little bit unique. So maybe the last to be considered, you know, even Bellingham Municipal and I think District Court also understand that there's certain what they, you know, who they would appreciate as low-level offenders that they assign to these incarceration alternatives. In Superior Court, we just feel like we have less of those that would benefit from it, but that does not mean that there aren't individuals that are deserving of it or it would be a better option for. So that's kind of a historical just aversion to it. Then there's also liability concerns. I met with the civil prosecutors, the civil lawyers for the prosecutor's office who represent the court, and talked to them about some of the liability concerns. And I think we can make some progress on making those less of a barrier to this sort of program, and I'm trying to do that. But that's taken some while to move through it.
Raylene, Jill here. It seems you're not muted, but we're not hearing you talk.
Okay, can you hear me now?
Yes, thank you.
Okay, I'm gonna switch over. New computer, sorry, trying to make things work. Go ahead, Stephen.
I'm gonna ask the question that's sort of lurked through a couple of these conversations. I've been in these meetings for a number of years. We've been working on pretrial diversion and all of that for a long time. And yet Superior Court, District Court, Municipal Court, prosecutor, defense, I'm hearing that you still don't have data to tell whether we're effective. You still don't have data to understand exactly what we're doing. And I'm just wondering, at each of these points, are you dealing with your own little domain? Are some of us on the screen now not the ones responsible for this? Who is responsible for this? Is this something we could do together? Or is this something that has to happen in each of your silos? And why are we still at this point, I guess, is what I would ask.
Stephen, can everybody still hear me? Okay, thank you. I think there's a lot of different moving parts for data, and you've got different agencies, you've got different departments, you had a setback with COVID. You know, I could go, when I was working in a municipality, I could go to FDS and they provided me a spreadsheet of those that were on pretrial monitoring, those were that on home detention, those that were on bracelets for alcohol monitoring to see if they were successful, if there were violations. So between that and the pretrial services through district court, we did have some of that monitoring, but the pretrial services group through Superior Court started right before COVID happened. And then there was setbacks, there was new hiring, there's new people coming in. And you have new systems that are also being implemented, as well as new individuals in different departments. So trying to gather all of that stuff isn't just a simple process when you're looking at all of these roadblocks essentially in different silos. So I don't know that it's just a simple fix that we can switch the light on and it's going to work. Stephanie can attest to some of the data that she's assisting Alan Epps and Kelsey McDonald with. And each municipality and district court will look at their data a little bit differently. I'm sure that, you know, Jake is working on trying to figure out how stuff is done through district court, but you can go ahead and pull the caseloads and how many cases are done in district court and municipal court. But the pretrial services is still a fairly new animal that we have to work through. I don't know if anybody else has comments on that. Sheriff Tanksley? Sheriff, you're muted.
I don't have a comment on that directly, but I do have a comment before we conclude. So I just wanted to give you a heads up.
Okay, thank you. Judge Anderson.
You know, Stephen, the question is, how do you measure this? I guess, and maybe Jake can step in. What are we defining? We talked about successes. Like catching people with dirty UAs is a success for me. But do I track the number of violations someone has? Do I track if they make it to their court hearings? I guess what are we looking for to measure as the data? How many people are on it and they make, I mean, I could probably note FTAs. I could have Jake look into that, but I guess what data do you want?
I think that's really the major part of the point I was trying to get at, Judge Anderson. you know, I know the systems like FDS that you work with can spit out data that you'll get, and we have had bumps in the road for that. But your question, and I think Stephanie referred to it earlier as well, some of it is we have to define what those points are that we want to capture and rank how important they are to us and how critical they are to individual defendants' successes. But that's been asked, I mean,
Yeah.
this group can't answer that. We've been asking you all for a couple of years to come up with that and tell us what data you want to capture. And
Yeah, I guess that's my answer is, I don't think it's some of it's not capturable. Is why it's not captured is, you know, if it's literally, do people make it to the end of their court case? That is very capturable. Does someone get sober while on their probation, pretrial? I don't know. I know if they don't have violations or not. I don't know. I don't. That's why it's not capturable, Stephen. You know what I mean? It's an intangible of, are they, you know, are they showing up? And to me, it's even a success if they're showing up dirty every week. At least I know where they are. I don't know. Jonathan.
I agree with that. I mean, we
Yeah.
know that recovery is not a smooth arc, that there are slips and falls along the way. So a dirty UNA here and there doesn't seem like a failure to me either. It seems like
Right.
an expectation.
And
So-
I'm not offering, and the weird thing is pretrial, I can't offer treatment. I can't order them to go get services because it's pretrial. I can offer them. So it's if you're right, what matrix do we want to measure? I'd have to think on that a little bit longer and we could probably figure it out. But the easiest one is, do people on pretrial show up for their court date? Does the case resolve? We could probably actually measure that one, I think. If we're looking at these other intangibles of community safety and the other successes we talked about, whether they get sober, I don't think we can measure that. It's so intangible. It's so not a checkbox thing.
It seems like appearance and recidivism are the
Yeah.
measurable things.
Yeah. Thank you.
Well,
Judge
and
Anderson.
the numbers that have already that are gathered, like the percentage of pretrial detainees we have in the jail, and that's a number that's been going in the wrong direction, and time to trial, and the length of time that a criminal case is pending before it resolves either through plea or trial or otherwise. Those are hard numbers that we can see, and I not that we always want to, unfortunately. But Stephen, I did want to answer your question directly too. From my perspective, I do feel rather siloed. I wish I didn't, but I'm new to this group, and I kind of expected, and maybe there was, and just the communication hasn't been that great to me. But I expected there'd be kind of a further along as far as kind of a plan of action, a package of data that we were pursuing. I know there were statisticians that were working for some time that seemed to be maybe directed to the PSA and not anything else. But I feel I've been here a couple months now, and I'm still kind of asking these questions and trying to figure out where the plan is, and I haven't found it yet. And so I do feel siloed in Superior Court.
Raylene, you're muted.
No, sorry. Judge Rance?
Thanks. I just wanted to comment on the measurability. But if we strip it right back, we're talking about pretrial supervision, right? And the purpose of pretrial supervision is to make sure that we're using least restrictive methods possible to make sure that the community is safe and people attend court appearances. So I guess a measure could simply be how many people on pretrial services or pretrial monitoring don't bench warrant, because that means that they're following the conditions of release. But at the same time, I also think, like Judge Anderson does, that if they're subject to random urinalysis or even scheduled urinalysis and they're positive, I still don't think that that's a negative, because even though they're not following the court order, we certainly know that we're intervening and we're holding them accountable. But the biggest problem with metrics is that's all really fluid. And so I guess success on pretrial is knowing that a person doesn't pop positive, and the amount of, but the only way they come before the court is if they're negative or if they're positive, right? And so it's really difficult, but I would say success can be certainly measured in the amount of people that get through to the case conclusion without new charges and ultimately without bench warrants. And along the way, we're going to see some of those things, but that doesn't mean it's a failure. It just means that they're being held accountable to the court order.
Thank you, Judge Rance. We are actually, I thought this was going to be quicker. And so we had a great conversation on this, and I really appreciate everybody's assistance in moving this forward and trying to help this pretrial services group come up with better data and see what we can explore to make it better. So thank you for the robust conversation. We are going to forego the implementation plan changes in the court system discussions. I'm sure we'll schedule that for another meeting. And that's topics for the next meeting. So I do want to get back to Sheriff Tanksley on other business, and then we can do public comment.
Well, I certainly thank everyone that's here, but so I've been here, believe it or not, 7 months now. So I'm reviewing our booking restrictions, and I've met with several people in this group. There's some people in this group I'm going to be meeting with in the next few weeks, and there's others that I need to meet with. One of the things that I would like to see happen before any booking restrictions are modified or changed is we're actually taking a look inside the jail itself with regard to efficiencies. And I would like to see all of our municipal courts come back in person for the arraignments versus doing it via video. And I know that we've had some recent issues with the language line and trying to get interpreters and things of that nature. So I'm willing to sit down and talk. And I know earlier in this meeting, we talked about different ideas and, all those different things, because we're all in this together. So certainly, if you have some ideas to increase efficiencies on your end or our end, if you have some ideas, say, hey, Tank, perhaps maybe the sheriff's office could do this, could do that. I certainly want to hear it. And, so we can have those conversations. But we're looking to modify the booking restrictions, hopefully this fall. And there's a lot of stakeholders in this, including the community. So this isn't something that I want to do just overnight, but I want to do it in phases. So, thank you. You're muted, Raylan.
It's actually the computer setup here. I got to figure out how to fix that. So thank you, everybody. We'll continue this on some of the other topics. We'll entertain more at the next Legal and Justice Subcommittee. But is there any other business that we need to touch on today? No. Okay. Jill, do we have any public comment?
We do have a couple of attendees. If you would like to speak to the committee, please virtually raise your hand now. No hands are raised. Peter, is there anyone with you in the conference room?
All by myself.
Thank you, everyone.
All right. Well, thank you for everybody's participation. We are going to adjourn the meeting at 12:40 this afternoon. Have a great afternoon.